The second part of the lecture deals with what I call the canonical instruments, the major documents in the history of the rule of law. And of course, I start off with Magna Carta. 15th of June, 1215, King John. He reluctantly signed Magna Carta. It was imposed on him by the barons. He had no intention of observing Magna Carta, and he did not do so. It was the price he had to pay, that is his signature, in order to get a respite from the superior baronial forces. When all is said and done, the importance of Magna Carta in the history of the English Constitution and of the British Empire cannot be questioned. Magna Carta contains 63 clauses, of which 5 are worth noting today. These are the 12th and 14th, dealing with taxation, and by and large they said that the king can no longer impose tax without the consent of the taxpayer, really. The more important parts of the Charter are the parts dealing with imposition of penalties without the force or support of law. Clauses 39 and 40 were as follows: no free man shall be taken or imprisoned or dispossessed or outlawed or exiled or in any way destroyed, nor will we, the king, go upon him, nor will we send upon him, unless by the lawful judgment of his peers or by the law of the land. So, no arrest, no imprisonment, except pursuant to law. That's the ideal. That's the rule of law ideal. Article 40, to none we will sell, or to none will we deny or delay right or justice. Again, a rule of law ideal. The connection between these provisions and Dicey's first meaning of the rule of law is obvious enough. There was, interestingly, a provision in Clause 45 that only those who knew the law well and were able to maintain it were to be appointed to the judiciary. I don't think he observed that. But it is a pointer to the more modern judiciary. Magna Carta was a part of English law which was received into New South Wales on settlement in 1788. The High Court of Australia has referred to Magna Carta in 40 cases, the Federal Court of Australia in 38 cases. And remember, the Federal Court was established only in 1976. And the Supreme Court of New South Wales in 32 cases. Now, having said that, let me immediately acknowledge that in not one of these cases, not one of them, has Magna Carta been relied upon as the decisive precedent which led to the result in the case. So I don't want to give you the idea that Magna Carta is daily playing a part in the deciding of cases. It's not. But the fact that it's been referred to so many times indicates that it is still a great symbol of the rule of law as opposed to rule by discretionary power or political power.